Hey, my name is Robbie Crosier. I'm a mergers and acquisitions attorney and a partner at Peters Kussmaul Crosier in Dallas-Fort Worth, Texas. And today I'm going to talk about caps and baskets. You can really think about caps and baskets as levers that you can pull to either expand or contract the liability that a seller would experience in a business acquisition. These are going to usually be pretty heavily negotiated in a deal. It's one of the things that we would focus on as legal counsel for either the buyer or the seller. And where the parties ultimately land is going to determine how much leverage the buyer is going to have post-closing if any problems come up. So on the top end, you have caps, which a cap is meant to be kind of the total amount of liability exposure that a seller can experience because of something they did or didn't do. Essentially, if they breach some part of the purchase agreement or they misrepresent something that doesn't quite rise to the level of fraud but is a misrepresentation or otherwise cause some kind of breach of the agreement, a cap is meant to limit their exposure to a certain dollar amount. So if the parties agree, for example, on a 10% cap, which is, we see caps range anywhere from 10 to 20%. The bigger the cap, the better for the buyer because they can reach in and make sure that they're made whole because they have a bigger dollar amount pool to try to go after. The smaller the cap, the better for the seller because the buyer is limited to only going after them for whatever that lower amount is. I would say that maybe 10 to 15% is a more common range that we see. But we have seen caps go all the way up to 20% depending on the leverage of the parties. And a lot of this is going to depend on who has the leverage in the deal. And who, frankly, if the parties have good attorneys who kind of know how important these things are and how to negotiate them. So on the seller side, the seller's goal is going to be to keep the cap as low as possible. So the buyer, if the buyer comes after them for something, that amount is relatively limited. So the seller's generally going to try to make sure that cap is 10% or even less if they can get it less than 10%. I rarely see less than 10%. And the seller, in addition to that, is going to want to try and make sure that as many issues, as many problems that could arise are included in that cap as possible. The alternative to things, issues, problems being included in that cap are what we call carved out of the cap. So the buyer is going to try to do the opposite thing. They're going to try to say, we want to try and make sure, one, we want to make the cap as high as possible so the seller's exposure isn't limited. And two, we want to make sure as the buyer that as many issues as possible are carved out of the cap, meaning that the buyer can go up. There may be, let's say, a $300,000 cap in the deal, but there are certain issues that are so big that the buyer and seller agree to remove them from the cap. And essentially to say, okay, if these massive issues arise, then we're not limited to the $300,000 cap. We can go way beyond that. Maybe there is no cap. That's uncapped liability. Often in the legal world, and in these purchase documents, you'll see those things categorized as fundamental representations, which are usually going to be uncapped, and non-fundamental representations, which are usually going to be capped, or if the parties negotiate a cap. There's some confusion due to those naming conventions. Non-fundamental caps, or non-fundamental representations rather, are still very important. Those are often going to have to do with the state of the business. So what assets are being sold, what quality are those assets in, what representations about the company has the seller made. Things that are really material to the buyer are still categorized as non-fundamental representations on the legal side, which is really just a way of determining or making it clear that those things are included within the liability cap. So it's not uncommon to see non-fundamental representations, which are still important things about the business that you're going to care about, being capped at some dollar amount. The fundamental representations are what are almost never capped, and should, if you're the buyer in a deal, you never want those to be capped. But those are pretty limited. Those are generally going to be the ownership of the business. So does the seller in this deal really own the assets or the equity that are being sold? And are they who they say they are? And are they committing fraud? Fraud is generally going to be uncapped. And then tax liabilities are often uncapped as well. So if there are certain tax liabilities that might follow the seller, you as the buyer don't want tax liabilities coming with you for things that you maybe couldn't have known and shouldn't have been responsible for. So those things, fundamental representations, tax liabilities, fraud, are generally going to be outside of any liability cap. And the question really just becomes then, because as you've probably gathered at this point, the vast majority of issues that would be encountered in a deal like this are going to be within the caps. What's the total amount of that cap, and what is the total level of risk exposure that the parties are comfortable with? On the flip side of that, you've got what's called a basket. The basket is if the cap is kind of the upper bound, the basket is the lower bound. The basket functions sort of like a deductible in insurance. Its whole purpose is trying to make sure that the buyer does not have the ability to nickel and dime the seller after an acquisition. A basket can be anywhere from 0.5% to 1% of the total purchase price of a deal, or more or less, depending on what the parties agree. And its function is essentially, hey, if there are issues that come up after closing that the seller may have been liable for, the buyer cannot go after the seller for any of those issues until they hit a certain dollar threshold, until they essentially exceed that deductible. And after that threshold, then the buyer can be made whole. There are two different kinds of baskets. We know them as tipping baskets or true deductibles. Let's say that the basket we're talking about is $5,000. That means the buyer can't go after the seller for any money until they hit $5,000. In a true deductible, once they hit $5,000 and exceed it, the buyer can only recover the amount that has been exceeded. So anything over the difference, anything over $5,000 in this case. So if the buyer was damaged for $5,010 and there was a true deductible, the buyer can only recover $10. They cannot recover that entire $5,010, just what's over that basket. Whereas in a tipping basket, the alternative kind of basket, the buyer can recover the full amount from the first dollar. So if there is a basket of $5,000, it's a tipping basket, and the buyer was damaged for $5,010, they can recover all $5,010 after they exceed that $5,000 threshold. Similar to the cap, this is a negotiated point. The buyer is going to want a lower basket. The seller is going to want a higher basket. The buyer is going to want a tipping basket, and the seller is generally going to want a true deductible. All of these things are negotiable, and again, a lot of this just depends on the leverage of the parties and how much the parties know about these things and how much risk they're anticipating. So I hope that's helpful in you determining what makes sense for your specific deal in terms of baskets and caps. Again, my name is Robbie Crosier here at Peters Kussmaul Crosier in Dallas, Fort Worth, Texas. If you need anything, have any questions, please don't hesitate to reach out.